Hi, good evening. I'm K Singh, a real estate consultant. And on this explainer series today, we are discussing the most important law that protects and safeguards apartment ownership and rights over common areas in any built-up project across Haryana. In most projects, buyers believe that once possession is received, ownership is complete. Keys mil gaye, registry ho gayi, flat mil gaya, owner ban gaye. But legally speaking, ownership without compliance is incomplete. And that gap between possession and legal ownership is exactly where most disputes, misuse of common areas, builder control, and association failures begin. The law that bridges this gap is the Haryana Apartment Ownership Act 1983. This act does not deal with marketing brochures, launch offers, or payment plans. It deals with power. Who owns the land beneath your building? The Haryana Apartment Ownership Act 1983 governs who controls common area and decides on maintenance. It establishes who is legally entitled to govern the project once construction is over. This act converts buyers from flat holders into statutory owners. It converts common areas from builder-managed spaces into collectively owned property. And it converts informal societies into legally enforceable institutions. In this explainer series, we will clearly understand where this act applies and where it doesn't, what types of properties come under it, who is responsible for compliance, the builder or the buyers, how is ownership legally created, not just assumed, what rights owners get over common areas, what obligations cannot be avoided, and why ignoring this act weakens even a registered sale deed. So if you are a buyer, an investor, an RWA member, or a professional dealing with real estate in Haryana, this law decides how strong your ownership really is. Let's begin by understanding what the Haryana Apartment Ownership Act 1983 actually is and why it exists. This act is the law which converts apartments into independent immovable property, transfers power from the builder to apartment owners collectively. It defines who controls land, common areas, money, and governance. The Act is a special property law enacted to regulate ownership of individual apartments and rights over common areas and facilities. It also defines the obligations of apartment owners, the formation and functioning of the association of owners, and the legal enforceability of collective decisions. It separates ownership and possession from governance. What is its territorial jurisdiction? Where does the Act apply? It covers the entire state of Haryana and applies to built-up properties submitted under this Act through a registered deed of declaration. Under this Act of 1983, the primary responsibility to bring a project under the Act lies with the builder, colonizer, or original owner of the land. A builder or landowner is legally obligated to execute a deed of declaration. Declaration must cover the entire built-up property, clearly defining apartments, common areas, and facilities. Specify the percentage of undivided interest for each apartment. The builder or landowners are obligated to register the declaration under the Indian Registration Act 1908. Complete this process within the prescribed time after obtaining the completion or occupation certificate. Until this is done, the project remains legally incomplete under this law, regardless of possession or sale deeds. Once the declaration is registered, each owner must execute a deed of apartment and become a member of the association. The owners must comply with the declaration under this Act and the bylaws of the association. They must contribute to the common area maintenance expenses and follow the decisions of the association. Failure to file and register the deed of declaration is not a procedural lapse. It is a statutory offense, a criminal liability on the builder, colonizer, or landowner. For non-compliance under this Act, there is an imprisonment up to 3 years, with a minimum fine of Rs 50,000 in addition to Rs 10,000 per day for continuing default. More importantly, non-compliance results in a weak or disputed ownership over common areas, continued informal control by the builder, and inability of owners to legally enforce collective rights. This leads to fragile or non-enforceable RWAs with prolonged disputes over maintenance, parking, and facilities. If the builder does not comply, buyers may have possession but not statutory ownership. Common areas remain legally vulnerable. Governance operates without full legal backing. And if owners remain unaware, non-compliance quietly becomes permanent. That is why under the Haryana Apartment Ownership Act, compliance is mandatory and delay is harmful. This Act applies to buildings divided into apartments including multi-story residential or commercial, retail or office, IT or ITES parks, mixed-use developments, serviced apartments. An apartment means a residential or commercial unit capable of independent use, which has access to a public road or common passage. It must be identified by number, location, and floor plan. The Act does not apply to independent plotted houses, builder floors if not declared under this Act, undivided commercial complexes, and temporary structures. These are the key exemptions. Once governed by this Act, each apartment becomes heritable and transferable immovable property. Ownership is absolute, not conditional on builder control or interference. Primary responsibility lies with the landowner, colonizer, or the builder. They must execute a declaration, and register it within 90 days of completion or occupation certificate. The Act defines land details, apartments, and common area. It also covers undivided interest percentages and the intended use of the property. The declaration under this Act is the constitutional or a birth certificate document of the apartment property and ownership. Without this, the legal separation of apartments, enforceable common area rights, lawful association governance, legally impossible. Every apartment owner must execute and register a deed of apartment linked to the declaration. This defines exclusive ownership, including undivided interest in the common areas. Common areas include land beneath the building, structural components, staircases, corridors, lifts and common lobbies, parking, basements, open spaces, parks, utility systems, and management rooms. Legal principles of common areas. Indivisible, cannot be sold or partitioned, cannot be detached from apartments, always owned collectively. Each apartment under this Act carries a fixed percentage of undivided interest based on its daily price, governs voting rights, expense sharing, and the distribution of sale or insurance proceeds. So, the formation of Association of Apartment Owners is statutory and mandatory. It is the governing body of the property, trustee of common areas, and an enforcement authority. Who is the member? Every apartment owner. Tenants are not members but are bound by the rules. Membership is automatic, cannot be waived, passes with transfer of apartment. The association exists perpetually. It continues as long as the building exists under the Act. So, is independent of whether the builder exits or not or change in ownership. The association must maintain and repair common areas, assess and collect common expenses, insure the property, maintain accounts and records, enforce bylaws, represent owners legally. Consequences of non-payment or unpaid common expenses. They become a statutory charge on the apartment, ranking above all charges except government taxes and the first mortgage. During transfer, transferor and transferee are jointly liable. Consequences of restrictions: owners cannot damage structural safety, alter load-bearing elements, or encroach on common areas, or add structures without consent. Violation invites legal action. All are bound by this Act, declaration, bylaws, association resolutions. The Haryana Apartment Ownership Act 1983 allows a property to be removed from the operation of the Act, but only with the unanimous consent of all apartment owners. The Act expressly provides that removal from the Act does not bar or prohibit the property from being resubmitted to the Act in the future, again through due process and consent. This Act is foundational as it converts buyers into owners, societies into legal institutions, common areas into protected collective property, limits builder overreach permanently. If RERA regulates how projects are sold, this Apartment Ownership Act governs how communities live. Ignoring this Act means weak ownership, fragile governance, and endless disputes. Understanding it means control, compliance, collective strength. Legal disclaimer. This video is for educational and informational purposes only. It does not constitute legal advice or professional consultancy. Viewers are advised to consult qualified legal professionals before making any decision.